Good evening. Tonight, the Supreme Court of Kenya holds its pre-trial conference for 3 presidential election petitions. The court seeks to address petitions filed by former Kilome Member of Parliament Harun Mwau, activists Njonjo Mue and Khalef Khalifa, and that of the Institute for Democratic Governance. Mue, Khalifa and Mwau want the outcome of the October 26th fresh presidential poll invalidated, while the Institute for Democratic Governance wants opposition leaders Raila Odinga and Kalonzo Musyoka held in contempt and found guilty of electoral malpractices for actively seeking to derail the poll. Though through his lawyers, President Uhuru Kenyatta, who is listed as the 3rd respondent in 2 petitions challenging his re-election, applied to strike out opposition leader Raila Odinga's coalition from the said petitions. Kenyatta says Odinga should be treated as a stranger, having withdrawn from the repeat presidential poll. Some of the concerns raised in the course of the applications today border around voter identification and the absence of Forms 32A, as well as questions over whether Raila Odinga formally withdrew from the repeat poll. The court has 7 days left to hear and determine the petitions, with the constitutional deadline lapsing at midnight next week on Monday. Tonight, we will be speaking to 2 lawyers on this. I'm joined by Muthomi Viankolu and Steve Ogola, both advocates. But first, let's cross over to the Supreme Court, where the 6-bench judge is set to conclude that pre-trial conference. Our lead reporter on this, Sophia Wanuna, joins me now from the precincts of the Supreme Court. Sophia, good evening. We understand they're about to go back into court any moment now, but just update us on the goings-on at the Supreme Court from 11 o'clock today.
Good evening, Yvonne. Today is the 8th day in the 14-day timeline by which a presidential election petition must be heard and determined by the apex court in the land. And today is also the day set apart for that pretrial conference that began at 11 a.m. It has been a long day. A lot has been said. Let's try to break it down before the judges come back to continue with that pretrial conference. So there are 3 petitions before the Supreme Court of Kenya. The ones that you mentioned, Harun Mwau, and the basis and grounds on which he's seeking to have the re-election of President Uhuru Kenyatta annulled is that a nomination exercise should have taken place before the repeat presidential election. Today we've not heard, regarding that, we've not had much regarding that particular petition in as far as applications are concerned. But on the 2nd petition, that's Njonjo Mue being the petitioner 1, petitioner 2, Khalef Khalifa, there have been several issues. They're also, of course, seeking the nullification of President Uhuru Kenyatta's election. They also argue the nomination exercise should have taken place, but also they're making and made an application for a scrutiny exercise to be conducted. And in their prayers, some of the areas they want to be able to look further into are all the statutory reforms, 34A, B as well, even 32A, which are part of what a voter who's not identified using the requisite biometric features or a gadget should be able to fill in to be able to account for that. They also want a non-redacted KPMG report on the voters register. That's also one of the applications and prayers they've made. Also SD cards, the KIMS kit, and the to be able to get GPRS of each and every one of them. Extensive, about 15 in number of the areas they want to be able to scrutinize, and they made those prayers in their submissions today in court on that scrutiny exercise. That's an exercise that was opposed by the IEBC. IEBC described it as a fishing expedition. They said that it's also not in good faith, arguing that in fact they have made available to the court and to this respondent, rather petitioners, all of these documents, gadgets and other areas that want to venture into. They made all of that information available. So they argue that it's also not reasonable in as far as the timelines and the constraints in this petition to be able to canvass the scrutiny issues that have been raised. Yvonne, Counsel for President Uhuru Kenyatta, who's also a respondent, got to address the application for scrutiny. And one of the things we heard from Ahmed Nasser Abdullahi is in relying on the judgment of the 1st of October in the first presidential petition, he said that according to him, the judges relied 98% in coming to their decision on the scrutiny exercise that they ruled on the 28th of August. So in his argument is allowing this scrutiny exercise would be to give life to a petition that to him, as it stands right now, there is not much to it. He says that this will resuscitate as it did the last petition. This will do the same in this particular case, and so argues that prayer for scrutiny should not be granted. In fact, he goes further to ask the judges of the Supreme Court to go back on their decision in the first petition, saying that that was not sound law, is what he told the judges. They should not have ruled as they should, saying access to information are not matters that should be coming before the apex court. Instead, they should be conversed at the High Court. So that is one of the applications that has been made by Njonjo Mue and Helef Khalifa. Now, there are two applications that have been made against them. One by the IEBC. And IEBC is seeking to strike off an application, or rather is applying to strike off the request for memos. And the memos, rather, that have already been cited in the petition by Njonjo Mue. They say those internal memos leaked and they are not information that was provided by the IEBC. So they're irregularly in this petition, that they were illegally acquired. That is what they're making prayer of. However, Njonjo Mue and Khalifa's counsel arguing this was information in the public domain, that in fact, in the application for scrutiny and access to more information, they request for more of the other memos and in-house information within IEBC. Yvonne, another request that has come against the Njonjo Mue petition is from Uhuru Kenyatta's counsel. And they're arguing that their petition was not filed in accordance with the strict procedures outlined in law, that on the deadline, which was 6th of November of filing the petition, they only filed 2 full petitions, and as far as all of the requirements, attachments, affidavits, and all the volumes required. However, 6 of them were not filed, were filed the next day. And so a lot of back and forth on that particular issue in open court, with Njonjo Mue and Khalifa's counsel arguing it was because there was such a long process and that they, in fact, argued they were advised to come the next day. So that's another prayer that's there. So 3 applications on that front. Then there's the other petition, Yvonne, and that's by the Institute of Democratic Governance. Yvonne?
Yes, carry on. I'd just like you to finish that because I'd like to get some input from my guests before the judges come into court, but I'll let you finish.
Yes, so quickly on the IDG, you have Jubilee Party seeking to be enjoined, and they are arguing today in court that they want to be able to participate in this particular petition because they have voters and supporters who are in the Jubilee Party and would be affected adversely by the same. On the other hand, Uhuru's counsel want Nasser, who are the 4th respondent, the Khalifa's matter, to be removed, arguing that they boycotted an election, so they should not be party to this. In fact, adding that if they participated in this presidential election petition, it would be like 2 petitions, and it's in fact a petition through the back door. So Yvonne, in a nutshell, some of the issues we've seen arise today.
Okay, just quickly before I come back to my guests, what are we expecting as the judges come in at 8 o'clock or any moment from now?
So they've canvassed these issues. They are yet to fully handle, at least in open court, all the applications before them, including amicus curiae, which the Attorney General has requested to be admitted, and others. There are a total of 15 applications before them. However, they said on some of those, they'll rule and decide on them based on the written submissions. When they come back this evening, Yvonne, one of the things, very important things we've not seen happen, is agreeing on the actual issues that will come before the court for hearing. Hearing is likely set to start tomorrow. So they need to decide on that, of course, with the engagement of counsel. The other thing is timelines. How much time does each party take? And also, more importantly, these other applications on who should or should not be engaged. The judges must rule on all those applications before hearing proper commences.
All right. Thank you very much. Sophia Wanuna, our lead reporter at the Supreme Court, for the entire duration of the show and indeed of the Supreme Court petition that is currently underway, day 8, like she says. Gentlemen, thank you for being with us. Muthomi, I would like to start with you. primarily, before we even get into some of the issues, what do you see as the major differences between, I mean, we've had, what, 2 petitions in the space of 2 months? What do you see as the differences, you know, between this case and the other, even in terms of the petitions? The other time it was 1, now it looks like we're facing more than 1.
Many thanks, Yvonne. In the case that was filed in August, the main issues revolved around electronic transmission of results and the use of ungazetted polling stations. At least in my view, those were the main serious allegations. Of course, there was the time to that, the whole question of infiltration of the ICT system and alteration. That case really turned, in my view, on the orders of scrutiny that were given by the court. That gave a huge boost to the petitioner's case, and eventually the ruling was that there were illegalities and irregularities, largely revolving about the steps that happen once the counting of votes starts up to the point of declaration of results. Yeah. Now, the petition by John Mwe, which in my view is the most serious petition among the 3 currently before the court, the main thrust of that petition is, number 1, the court in its decision of 1st September set the threshold for what a transparent, free, fair election under our constitution is. And in summary, his complaint is that the IBC, in conducting the election of 26th October, has disregarded that legal threshold, which is another way of saying that the IBC has not conducted this election in accordance with the decision of the Supreme Court. Of course, we don't have time. There are several details, very, very many of them, in fact, that he gives as to why he contends that is the position. The petition by Aaron Moao raises an issue which was not in the petition of August, which is the question of nomination. Yes. This issue actually only became live. Was this a
fresh election, a rerun, a repeat exercise? Yeah.
Yes. It is the main issue. He still raises some of the issues you find in the George Omwe's case, but the definitive issue raised in that petition is the question of whether there ought to have been a fresh election.
Right.
There is a
meaning starting from the nominations all the way.
Yes, and time permitting, we'll get there. Yeah. The last petition is about, I'm not sure, speaking for myself, it's actually an election petition, because it is curious in many ways.
In what ways is it curious?
You see, an election petition has its aim and focus in validating an election.
Okay, so it's to challenge the election,
the
process,
the validity
the numbers,
of an election. Now, that particular election petition is not challenging the result of an election. So the question, therefore, is it an election petition then in the first place?
Right, okay. And those are some of the questions that, you know, the Supreme Court judges will be seeking to determine whether they can be, whether they consolidate all of these cases and perhaps whether that one will be included as they hear it. I mean, they could hear it separately.
Well, I think, Yvonne, thanks. Maybe just to make a preliminary observation, looking at the demeanor and the manner of responses by the Guru's team and IBC, there seems to me that they privilege an approach that election or election dispute resolution is a mechanical exercise that requires a mechanical response. If you look at the spirit of the Constitution, interrogation of election management is actually the quest for transparency and accountability from those who are charged with the responsibility of managing election. That is the technical design of the Constitution. So that then, if you, like the time spent today in dealing with preliminary issues, these applications, there are several decisions that, some from the High Court, some from the Supreme Court, including the decisions, the rulings made in the August petition, August 8th, after following the August 8th election, that the court is not going to give undue regard to technicalities. So that once a party has filed 2 complete sets, or even 1 complete set, you could make copies, and then so that in the spirit of really moving into interrogating the issues, as opposed to delaying and winning a case through craft, you know, and technicalities. I think that is not what the Constitution requires, and we must reach a level, and I've seen this in litigation, because some of the cases we've done, I'm sure Mudomi has also experienced the same, you still have a mechanical response to litigation. People who are litigating in public interest matters, it requires sometimes that even the state, like the Attorney General and even other parties, they also isolate what they think. They should view these election petitions and any other matter that is of public interest as seeking to bring clarity in management. Okay. And therefore, by consensus, you see, the court need not spend time and resources trying to sit down to deliver a ruling on what appears to be a practical sense issue. The fact is this: the petition was filed in time. Yeah. If you are not served in time because there are less copies, there are some, because of some could be some normal errors or maybe mistakes. But really, they know that the court, this Supreme Court, will not give a ruling that reverses the decision it made in the other petition. Because we are just reading the other rulings, they'll say, we are looking at the spirit of this petition. Let us just go and interrogate the issue. I wish there was some learning, and I find that to be discouraging coming from senior lawyers who are supposed to lead by example, that this time now the Constitution has shifted or transitioned us from more a mechanistic, formalistic approach to litigation to a more purposive approach where you interrogate what is the issue, and IBC equipping itself to respond holistically to the issues that have been raised.
I'd like us to also talk about, and just a reminder to our viewers that we are still waiting for the Supreme Court judges to come back in and deliberate on the preliminary issues that have been set before them and set the ground rules and, you know, sort of housekeeping for the proceedings going on. So we are monitoring that, and as soon as they come in, we will take you there straight away. Obviously, it's instructive to note that once again, it's the 6 judges. You know, Justice Ibrahim, you know, still indisposed and not able to hear this petition. But so let me ask you this, because I've seen this in the Njonjo petition and discussing the environment in which we had this repeat exercise. Mudomi, how does that become a legal question or a legal argument when we're talking about, well, there was quite a bit of rhetoric that was coming out after the Supreme Court verdict on September the 1st, and of course the more recent judgment that they gave later. Talk to us about that argument, about the atmosphere in which we conducted the October 26th repeat poll.
You see, Yvonne, the question of atmosphere is tied to what my colleague was saying. What many of us don't seem to have realized, and this includes even senior lawyers, and for me, I'm not actually surprised because it's natural to expect senior lawyers who went to the old law school not to appreciate, is the paradigm shift from the use of litigation as a forum to wage battles of wits to a forum of addressing substantive issues. So for me, until we understand that, back to your question, the Supreme Court ruled on first, and I must point, this is not the first time our court ruled as such. I know decisions that are more than 10 years old, that an election is a process. And if along that process, the environment is one that creates intimidation, creates fear, creates improper influence, all these things are actually addressed in our Constitution. And one of the things it says is that an election shall be free from fraud, from intimidation, and from corruption, and from other forms. Actually, the language used is one that is illustrative in character, all forms of improper influence. Of course, at a litigious context, one, you have to show, as the person alleging, that the prevailing circumstances do not correspond to that constitutional ideal. Having done that, you must go further and lay the blame for existence of those conditions on either the IBC or any of the other parties to the election petition.
But let me ask this of that and where you're laying the blame, Steve. Yes. But can it be said that the IBC should not have presided over an election under these circumstances, whether or not it was their doing? Because it could be some circumstances that are out of the IBC's control. I think
perhaps the manner in which IBC was responding to the determination, the September 1st determination, could as well have led us to where we are in a litigation contest. What I think where we may have missed a critical point is in the framing of the organizing question. Is it that elections we're supposed to improve gradually so that we are looking at the quest, election as a quest for improvement of the technique of governance. And you see, in terms of democracy, elections is at the center of democracy. And election helps us to organize the nature of government. So you must get it right. So the process of getting it right, so I think it's true that other than documenting the illegalities and irregularities, the environment and the context in which an election is conducted, you see, election is not conducted for people's amusement or just as a minimum or technical compliance with the law, as it were. Election is conducted for purposes of getting someone to have that popular mandate in a process that is transparent, that is accountable, that is verifiable, so that when the losers, when there's the winner, he wins for all, and then a loser also is able to be co-opted in that vision that truly the minority had their say, but the majority had their way, and now let us move forward towards building the nation. But where you have a process that leads to a majority having their way, but the losers feeling that the process that led to that declaration of a majority having their way was fraught with fraud and falsification, questions are bound to arise. And I think, I suspect that there's a bit of sloppiness on the part of IBC in terms of appreciating the new legal shift or the shift in expectations. The Supreme Court seemed to have said, or rather said, that reading the Constitution, as it were, the Constitution seems to ordain a new approach, an approach that requires an improved technique in election management, and the court was putting IBC to task that can you go back and improve your standard of election management to meet this new threshold. But you see, the moment IBC, what you could see the reaction after the determination, the first reaction by IBC, it was a bit indigenous because IBC said that we are still waiting to get the reason so that we can understand. Surely the evidence tendered and what was observed and what the court used, if there was anyone who had a detailed understanding of the irregularities and illegalities, must have been IBC. So
for you, you're saying the environment is the way in which IBC responded to external factors.
And this started all the way from the 1st of September. IBC, the reaction that they would have privileged was, first of all, to own up to some mistakes. You see, election management is also largely a question of perception. You own up that you don't fault find the court, and the way Chiloba did, and by saying that I think it's alleged that he sent a memo congratulating the staff and saying that you did your best. I think at that time, what IBC ought to have done to minimize opportunities for suspicion and also to boost the confidence was to make some honest admissions.
Okay.
Making honest admissions
and you make an important point about honest submissions, because then, Dr. Roslyn Akombe's resignation is now making its way back in as an argument. And it's being cited in one of the petitions, Mudomi. So to what extent do you think, this will be an important factor of it, including that speech that was made by the chair, Wafula Chebukati, admitting to quite a number of the issues that Roslyn Akombe had raised? Of course, later on, we know what he said, that, he was now pleased with everything and, he was ready to proceed with that election. But the internal environment within IBC, that's going to be a factor.
For me, anyone who is genuine and honest, and Kenya seems to have an acute shortage of such people, the question is, if the chair himself told Kenya and the world, just a week to the election, that he couldn't guarantee it would meet the constitutional threshold, one of his members resigned, again citing similar reasons. If we had to take him seriously now this time round, what I would have expected, and I think even an half-wit would have expected the same, is Wafula Chebukati to come and tell the country, look here, gentlemen and ladies, on 18th I told you I couldn't guarantee a credible election. However, between 18th and 25th, which is 7 days, we have, by the grace of God or by sheer hard work or by some strange miracle, fixed all the things that I alluded to in my statement of 18th and take us blow by blow. Issue number one, he said that some commissioners were partisan and were countermanding his decisions. You would have told us those commissioners are now no longer partisan. Right. And they have recanted their past transgressions. Which
Njonjo, I believe, has also raised in his petition, talking about, influence of the commissioners, some of them.
He would have taken us through all the issues that inspired the statement of 18th and taken the country through how he had resolved them. Okay. Speaking for myself, it is an insult to my intelligence for anyone to suggest that issues of that fundamental nature were somehow mysteriously resolved in a span of 6 days, and voila, an IBC whose own chair couldn't guarantee an election would meet the constitutional threshold. And that's why I always say in these debates that maybe we get lost in the legalese and the technical aspects, and that enables us, unfortunately, to run away from the real issues and just engage in intellectual discourse and intellectual combat without addressing the problem. I would imagine, to answer your question, that any court properly addressing itself to the matter at hand would actually ask IEBC, tell us, you having yourself told us you couldn't guarantee the election would be credible, can you tell us what steps you took and why we should believe that in this incredible short period of 6 days,
you're able to resolve
you were able to resolve it? I mean, unless Kenya is another strange place where things happen like in science fiction, the truth is, for me, these people are just joking with our minds and maybe taking us for fools.
All right. Stay with me, gentlemen. Steve Ogola, Muthomi Thiankolu, both advocates, as we continue to discuss this Supreme petition. As you can see on your screens, in just a few minutes, we are awaiting the return of the judges back into the chamber to make determinations on the preliminary issues that were set out today during the pre-trial conference. Our lead reporter, Sophia Wanuna, is also on this beat and will be bringing us the latest. When we come back, I want to talk about the environment in which the judges themselves are hearing this case and what their determination will be based on. I mean, these judges live with us. They watch the news just like we do and are following all the events. What will be at the heart of determining, this case by next week on Monday? You're watching our special edition of the Supreme Petition. We'll be right back.